Welcome back and thank you for staying with us. So there could be a new twist in the Jacob Zuma arms deal trial. Judge Piet Koen is considering his own position in the matter. He's ordered all parties to make submissions to the court registrar by no later than the 3rd of next month on whether he should recuse himself from the case. Will this not further delay the start of the trial? Well, we're joined by legal expert Mpumelelo Zikalala from Zikalala Attorneys. Thank you so much, Mpumelelo. It's always great to speak to you here on eNCA. That was my concern when I looked at the fact that Judge Piet Koen says that he might recuse himself from this trial. It's already been such a stop and go for South Africans for so many years. Will this not take us back because a new judge would have to go through all the evidence that has come forward so far?
Good morning to myself and also to the eNCA listeners. Not necessarily. Let's remember that the merits of the matter have not been delved or discussed as yet. So we're still in the pre-litigation or pre-trial stage where we're still trying to get all the houses in order to make sure that everybody is ready to proceed with the matter. So the real crux of the matter is going to start when the first witness goes into the witness box and they start delivering evidence. Whilst they haven't done that at this particular stage, I don't think it is going to have any impediments in how this particular trial is supposed to be conducted. So it's still going to be delayed by things which are beyond the case at 10 division. For example, what is happening with the potential court and nothing else. And you do have other judges which will be there and that can be able to take over the baton from Judge Koen if he decides to recuse himself and to say, I'm not really in a proper space to deal with this matter due to certain pronouncement that I've made in the future or before even the trial is even started.
So what did you make of the arguments made by both sides in terms of when this trial should start? Of course, we've seen a lot of stops and starts with this particular trial, but particularly with President Jacob Zuma's team, former President Jacob Zuma's team, feeling that, the prosecutor should not even be part of the discussions around what's happening because of his application to privately prosecute. Does he have a leg to stand on with that argument?
Firstly, it was a bit of an ambush to come to court expecting to deal with purely administrative issues. And then you have an application which is going to take on for plus minus 20 minutes non-stop, where you can actually see that the prosecution came there prepared to make this particular application without any warning. I stand to be corrected on that matter with regards to the team of the former president. Now, they were correct in terms of saying we don't have any instructions or any mandates to either defend or to promote or to say anything with regards to what the prosecution is saying. So for now, we're simply going to reserve our submissions and at a later stage we can then come in. But that matter was settled since the matter is then moved on to the 30th of January because the judge indirectly said, I want to give an opportunity for the Constitutional Court to deal with the matter first and then you can be able to come back. Now, the crux of the matter when it's going to matter who the prosecutor is when the trial is supposed to start or when the trial is starting, especially taking into account the private prosecution stance or a case which is already going on within the Pietermaritzburg High Court. So I can almost anticipate a second application of saying, at the time we made the initial application, we had the prosecutor was not charged or not regarded as an accused. However, in this instance, the circumstances have changed and there are new facts in which we want to bring to the court and be able to the court to adjudicate on. So can you please adjudicate based on these new facts? Unless, of course, those particular new facts are going to form part and parcel of the submissions which are then going to be made to the Constitutional Court by the team of the former president. So it would depend whether they want to deal with this matter now or they want to deal with this matter at a later stage. But I do anticipate it's coming back at a later stage for it to be adjudicated or to be decided upon.
The argument about, private prosecution of Advocate Billy Downer and the fact that, there were some confidential documents that he shared with the journalist allegedly in terms of the former president's ill health the information around that, because at some point we couldn't continue with this particular case because of his ill health. So, does that argue bias? Obviously it already is wrong to be sharing a person's personal information like that with somebody else. But is it a case of bias or was it a case of public interest?
It cannot be a case of public interest if you are going to break the law. Now, NPA Act is very clear. It says that any information which is in your possession or that is placed in your desk by you being a public prosecutor, for example, So that particular information can't be shared with anyone. It has to be only to be shared in a proper manner. And if a journalist is going to have access to those documents, either it's going to be through an official spokesperson of the NPA, or it is through a court file which has been placed in court and information can be obtained from there. There was a reason why the legislature said there must be a section 41 within the NPA Act, because they wanted to protect the credibility and the secrecy, or let me not call it the secrecy, but the integrity of the information which lands in the hands of a prosecutor. Now, if you are then found to have broken that particular rule, there's no justification that can be found, especially now or without interpretation or determination by the court, which would then justify why the prosecutor engage in those particular activities. So what the former president is saying is that I'm not really concerned about my medical records. I'm concerned about any type of information that has been shared when it was not supposed to be shared in. Now, the prima facie evidence that I have now, or the instances that I think, or the sequence of events that have occurred, to me, they appear as if there's been a law that has been broken, which is why I need the court to then come in to simply ventilate this matter, adjudicate it properly, and make a determination. If at the end of the day, in which this particular matter could have been dealt with, then it's going to be fine. However, we can't ignore the fact that there is a law that has been allegedly been broken. It needs to be taken into account and discussed. With regards to the rights of journalists to source information, nowhere in the Act say that information can't be accessed by journalists. It's just that the proper time and manner and mode of accessing that particular information must be in line with the applicable legislation.
All right. So when it comes to Billy Downer as an advocate, then it means the former president has a leg to stand on in terms of the fact that there was a law that was broken. If that evidence is proven to be true, that he did share the medical records of the former president with somebody else, then it would seem that the former president has a leg to stand on. But the NPA is on its advocate's side. They're saying that they will keep Billy Downer on this particular case. They believe in his innocence, and they're behind him. What do you say to that?
It also makes sense that they're correct. Let's remember that all the rights which are applicable to any accused are also applicable to advocate Billy Downer. So our constitution says you are presumed innocent until proven guilty. So if there's no case number, that there's a court order, a ruling that says advocate Billy Downer is indeed guilty, we can't brand him as a guilty individual or as a guilty prosecutor. So there's no way in which, when he stands up in court as a prosecutor, we can then say, you do not have charge to prosecute because you are found guilty in a particular matter. And you can't say you can't stand up in court because you are an accused in a particular matter. It wouldn't be fair to him, in as much as it is not fair to all the other accused who are then branded as criminals by virtue of being in the particular accused box without evidence having been led that may prove whatever allegations are coming about. So the NPA is quite correct in terms of saying we are going to have our prosecutor prepped and ready to deal with the trial up until the time where we receive an order from court that says now your prosecutor has changed from having the status of an alleged perpetrator or an alleged individual to the status of that being a convicted individual. Only then will then reconsider whether he is charged to prosecute or not. But before we have that, let him continue prosecuting this particular matter and executing his duties as per the NPA requirements.
And that's only fair. So, Mpumelelo, I'm going to ask you just one more question that has nothing to do with that particular case, but the case of the Johannesburg mayor, that sitting that saw her ousted, was it right or was it lawful or unlawful, etc.? She took it to court yesterday, and without asking you to get into the politics of it all, I just want you to help me with the arguments and what you thought of them yesterday. So what she's saying is that what her lawyers are saying is that what is unlawful is the fact that the sitting was announced to council at 6 p.m. on a Thursday to tell them that there'd be an urgent sitting at 10 a.m. the next day, on the Friday when she was ousted. And she said, and you might remember that she did take papers to court on an urgent basis to have them actually say that that sitting shouldn't happen. But court, obviously, because of the time, didn't, they struck that off the roll on the matter of urgency part. So she says that sitting wasn't supposed to happen because she only told them so late and she didn't give them time. But she also says she didn't allow them the ability to debate what would be on the agenda. But at the same time, the other side, which is Colleen Makubele, the speaker, the council speaker, she says, well, the former mayor always knew that part of the agenda would be a motion of no confidence against her. She's known for about 2 months.
Now, it comes back to certain, let's look at 3 legs. The first one is that of agency, in which the court would then say, is this a matter that warrants to sort of overstep or jump the queue in terms of the matters that you are dealing with? Is it something in which we do not give an order today or any other day? We are going to suffer irreparable harm, and there are no other ways of repairing the harm that you could have suffered. If the answer is yes, then we're going to grant you that lack of agency. But if we can't, your matter could be dismissed purely based on agency. Now, on the merits part, you then come back and say, what ought to have been done or what was done ordinarily, which is a generally accepted procedure of conducting these meetings. So if it has been done before that a meeting is called at 6 o'clock for matters to be discussed at 10, and the agenda is done in a manner in which this particular one was done, then you can't come back and say people were not given enough or adequate time, when maybe you even participated in certain instances or matters such as those ones before. So what you should have done is that you should have come to court on an urgent basis. And when you say an urgent basis, even if you say that the matter must be heard at 12 o'clock at night or at 6 o'clock in the morning, that's exactly what's going to happen if you give that particular direction. You fail to give or to adhere to that particular time, that means that you can even see that your matter is not even urgent. But most importantly, on the merit side, if any of the procedures have been sort of been flawed or been broken, then she may have a case. But most importantly, the courts will not stop there. They will say, what was the harm which was being prevented from taking place by placing these particular procedures here? Is there any prejudice which is going to be suffered by anyone? Are there any different outcomes that could have occurred if the correct procedure were to be followed? If the answer to that is no, then they're going to say, no, we have to live with the current situation as it is, and accept that it's the political principle and the political will of those that are in council and that are voting who fully decided that this is the manner in which they're going to vote in now, and unfortunately it includes you being ousted at the end of the day. So what the court is going to boil down to or concentrate on is the level of compliance on both parties and what the rules should have been and whether there was compliance with those particular rules, and also at the prejudice that may be suffered by the parties.
All right, Mpumelelo, thank you so much for your time. It's going to be quite interesting what happens in court when it comes to politics in this country. That was legal expert Mpumelelo Zikalala from Zikalala Attorneys.